Somebody sent me this article. I'm going to read it, and it's about a woman who sued a doctor. So Miss Cherissa Cheng sued her obstetrician for negligence over her childbirth, and she lost the suit. A woman who sued her obstetrician for negligence after she sustained injuries following the birth of her child lost her case against the doctor. In a judgment released on April 3rd, the judge found that the obstetrician had not been negligent. So this was her first pregnancy. She's 32 years old. She suffered a tear that led to her excreting fecal matter from her vagina for months, even after the doctor repaired the wound with stitches. So this is known as a fistula. I don't know. I feel like this description sounds so um I mean it sounds really terrible. I think they should have just put fistula and then explained it. Because now it sounds like it's some kind of random injury when this is a quite a known form of injury. Dr. Khoo, 51, is a senior consultant practicing at his private clinic. So Miss Cheng sued the doctor for negligence, claiming that he failed to obtain her informed consent before performing several processes. At her first consultation, she told the doctor that her mother experienced prolonged labor due to her cervix not dilating and eventually received an emergency cesarean section. Okay, so this issue of cervix not dilating or failure to progress is often not an actual medical issue. It's often created and it's caused by the impatience of the attending healthcare professionals. She expressed concerns about natural delivery, but the doctor assured her she would be able to deliver naturally. So in May, she was admitted to a private hospital around midnight to be induced. Okay, so I guess this is not a scheduled induction because they would do that in the morning, like 9 a.m. So in this case, if she came in at midnight, maybe she was already in labor and then she was induced, but she already went to labor. According to Miss Cheng, the doctor informed her that an emergency C-section was required at 9:25 a.m. and she consented to it. So about 9 hours of being in the hospital. However, the doctor told her he wanted to try something to see if she could continue with natural birth. Okay, here they give the term. He did a cervical sweep, manual widening of the cervix, for a second time, according to her. The doctor disputes this, saying all he did was a vaginal examination. During the labor, the doctor also made an incision to aid the birth and then applied pressure to Miss Cheng's abdomen. An incision to aid the birth, like where? I think this is talking about an episiotomy, which is an incision in the perineum, and then applied pressure, fundal pressure, to sort of push the baby out. Miss Cheng gave birth naturally around 10:35 a.m. So about an hour later. Okay. She, according to her, that these actions amount to battery. In law, battery means the unlawful and unwanted touching or striking of one person by another with the intention of bringing about a harmful or offensive contact. After being discharged, Miss Cheng noticed fecal matter coming out of her vagina. So she has a fistula. So there is a tear between the vaginal wall and the rectum, and that's why the feces is not coming out of the anus, but from the rectum, it's leaking into the vagina. Okay, so she gave birth on May 3rd. Okay, she went to see him on May 6th, so 3 days later. According to her, the doctor said there were gaps in the stitching he had done, and that she had suffered an injury in the form of abnormal connection between her rectum and vagina. And she underwent surgery to repair her injuries about 6 months after her child's birth. 6 months. Oh my God. She claimed that due to the incident, she developed postpartum depression and post-traumatic stress disorder. So a fistula can form through this injury. Like this injury happens either because there is a episiotomy done all the way like too far down the perineum. Okay, so you have your vagina and then you have the perineum underneath. So the incision is done either this way or this way. And then when it's done down, if it's too deep, plus um pushing too hard, plus maybe also, he was giving fundal pressure on the uterus, that can cause the tear to be bigger. That is where your rectum is. So then it's easier to injure your rectum. This is known as a fourth degree tear. Okay, so like, okay, injury, fourth degree tear, fourth degree um injury is one thing, but then he did not repair it. He didn't stitch her properly. Like 3 days later, she came, and then okay, so I mean, 3 days, she probably pooped like once or twice, right? Then, but the fact that it took like 6 months to fix the fistula, like that's too long. I don't know what happened in the 6 months. But then she sued him for not getting her consent to do the cervical sweep, but not the episiotomy. Disputing Ms. Cheng's points, the doctor said he had provided sufficient explanation on the purpose and benefit of the cervical sweep and that it was not standard practice for consent to be obtained. Yep, that's the medical system for you. Similarly, Dr. Khoo said it was not standard practice to obtain formal consent to make an incision and to apply fundal pressure, as these were routine procedures of natural vaginal deliveries. Um, well, it's not routine. And from my own research, doctors in other hospitals, they will tell but not ask. So they will say, okay, mommy, we're going to cut now. And then 1, 2 seconds later, then they cut. So they consider that as already informing. But they don't like make you sign a consent form or anything. And most women are not aware because this is usually done to first time moms and they're not aware that it's happening. So they don't know to say no before it happens. And unfortunately, because it's routine. Like every first time mom gets this cut, the episiotomy. And because every hospital in Singapore does it for all first time moms, then due to something called the Bolam Bolito test, Singapore Medical Association, they describe the legal test for medical negligence known as the Bolam test. Under the Bolam test, a doctor will not have acted negligently if the act complained of is supported by other respected doctors, so long as those doctors' opinion is internally consistent and logical, also known as the Bolito qualification. Together, this is known as the Bolam Bolito test. So, because these procedures are routine, then everybody agrees that they should be done. So then you cannot use it to prove that the doctor did something wrong. The judge accepted the doctor's evidence that he explained to Miss Cheng the purpose and process of a cervical sweep. He noted that medical procedures often involve numerous steps and routine actions. Requiring doctors to obtain explicit consent for each individual act within a medical procedure is impractical and would place an unreasonable burden on them, he said. The judge said that Dr. Khoo should have noted down the tear and its repair procedure, but did not consider the doctor's account of events inconsistent. Medical notes and reports are prepared to document critical facts about medical management. They are not intended to be a foolproof shield against potential litigation. It is impossible for doctors to make contemporaneous notes of every step of every procedure they perform throughout the day, as multiple events often occur simultaneously in medical practice. So, this also demonstrates the cultural dominance of biomedicine because they are just taken as fact and that it's normal, this should happen anyway, so you can't expect a doctor to document everything. He found that doctor had not been negligent in applying fundal pressure to help with the delivery given her fatigue. So this procedure of doing fundal pressure, like some doctors will do it and some don't, and some say it's dangerous. There are reports in the colonial documents, saying that the Bidan of before they did things such as giving fundal pressure, and they villainize this practice a lot. But then you see that, yeah, I think especially in private practice, it might be happening more. The judge said it was unlikely that the doctor's application of pressure caused the tear, as the baby's head was not in a position to cause such an injury. Well, I mean, who knows? Because the head is taking up the whole space. When it's crowning, it's taking up all the space in the canal. The judge deemed that the doctor fulfilled the required standard of care in repairing the tear. I think even the fact that he did not repair properly, that should have at least been some kind of negligence there. He did not repair the tear properly. Even he admitted that there were gaps in his stitching. So how come this judge is so good that he can say that, oh, the doctor repaired the tear well? Overall, it is clear to me that Dr. Khoo was not negligent as his diagnosis, treatment, and care are supported by a respectable body of medical opinion. So it just goes to show that as long as you fall in within the orthodox opinion or practice, you are pretty much protected. And I think this applies to other ideologies as well, not just medicine, biomedicine. The judge found that the doctor's management did not constitute battery, and he dismissed her claim of $36,000. Her manager at her business clarified that her termination was not due to her medical condition. Oh, so she was also terminated from her job. Okay. Okay, the reason she left those jobs. Okay. She's now a homemaker, but she admits that she can work and has been looking for a new job. Uh, the judge said, I find that Ms. Cheng has failed to prove her case and the action is dismissed. Well, judges are not medical experts, and I don't know, here they don't mention having any other expert witness, any other doctors. Um, and yeah, I think because we don't have any laws against, obstetric violence or unconsented care, then she has to file her suit based on battery. And I think that's hard to prove specifically in the medical context. So wishing her all the best. Hope she can heal from from her physical injuries and also the trauma and the postpartum depression and PTSD. All right, that's it. See you in the next video.